My name is Shem Otanga. I'm an IP partner at Cliff Decker Hoffman, incorporating KT Law LLP. Our IP practice covers a full suite of IP rights, from trademarks to patents to industrial designs and copyright to anti-counterfeit enforcement and advisory work from a corporate transactional perspective. A corporate brand is a very important element of your business. It represents your identity. It represents your culture. It represents what you stand for, your ethics as a business. It's particularly important because it's the main manner or the main mode through which your customers identify you and get to know where to find your products and your services in the market. Your brand gives you your identity that is exclusive or distinct from other competing businesses in the market. And so it is very critical that your brand be clearly identified and protected within the market in which you operate. So every once in a while, each business needs to reinvent itself, to recalibrate, to find a new direction, to inject some new life into its operations and even into its own identity. And that ordinarily leads, or usually leads, to corporate rebranding, where a business takes up a new identity, a new name, new brand colors, new identifiers for its products and services as a whole. Now that can re-energize and reinvigorate a business and do wonders for its books, depending on how it's done. And if it's done the right way, it can yield tremendous benefits for a business. A number of legal issues arise in the context of a rebranding exercise. Now, where a new trademark or a new brand is adopted by a business, the key consideration is whether or not that trademark or brand can be protected in the market or the country where it will be used or adopted following the rebranding exercise. And a number of factors are used to determine whether or not a business can protect its new brand from infringement by third parties. Registration of trademarks is the foremost mechanism that the law provides for the protection of trademarks and new brands against infringement. Now, in order to register your trademark, you've got to satisfy certain requirements that the law sets out. And those are set out broadly in the two categories: absolute considerations and relative considerations. So your absolute considerations are those considerations that have to do with the new brand that you've adopted, the intrinsic factors or elements of that own trademark. The law says that a new brand or a new trademark can only be registered if it has certain qualities, the foremost of which is distinctiveness or a capability to distinguish. So there are two separate things. But essentially what it means is that your brand needs to have the capacity to enable consumers to distinguish your products and your services from the products and services of your competitors. And if a trademark fails or a new brand fails that test, then it would ordinarily not be registrable. In terms of relative considerations, you need to ensure that the new brand that you adopt is not in use within the market. That is, third parties not using it already in the market, or using confusingly similar brands or trademarks for the same set of goods or services. If you adopt a brand that someone else is using or one that is similar to what someone else is already using, then you automatically would become the infringer, arguably so. And that is something that a business would always want to avoid in the context of a rebranding exercise. In addition to also checking what is already in use in terms of branding within the business environment or the market in which you operate, it is critical to conduct searches, availability searches for the new brand that you've come up with at the Trademarks Registry, which is maintained at the Kenya Industrial Property Institute. Just to check and see that no prior similar rights or similar trademarks or brands have been registered by third parties. The import of this is that if a third party has already registered something that closely resembles a new brand that you're taking up, then you would be excluded from being able to take up a similar brand or an identical brand. So it's always good to clear both market use and whatever exists on the trademarks register that's maintained by the government at the Kenya Industrial Property Institute. Right, so in the context of business growth and expansion through acquisition of other businesses, either in the same space or in a different space, what typically is known as M&A or mergers and acquisitions, the issues that I've spoken about relating to rebranding quite often arise. A company would acquire another and give it its own identity, right? Confer on it its own unique identifiers, either generally as a business or in relation to its products. Now, when the identity is conferred on the target entity itself, then a rebranding would occur in the context of a merger and acquisition. And we see this all the time when one business acquires another and then operates under the name of the acquiring entity going forward. Now, in such cases, in the context of mergers and acquisitions and those sorts of transactions, ordinarily a due diligence is carried out on the IP portfolio or the trademarks and the brand portfolio of the target entity, just to see that and make sure that everything is okay, that its rights are registered, that they are valid, etc., that they're not under any challenge from a disputes or litigation perspective and the like. But of equal importance is to check to see whether the acquiring entity's intellectual property can be used in the market in which the acquirer is actually entering. Assuming the acquirer is a foreign entity that's coming to set up presence in Kenya, for example, by acquiring a local business. The acquirer essentially must ensure that its own brands, especially if its brand will be carried over by the target entity, must ensure that its brand is available for use and can be protected in the market in which it's entering. So searches ought to be conducted, again, in the market and at the same time also against the trademarks register that's maintained at the Kenya Industrial Property Institute. Now, we've seen situations where acquiring entities that are entering the Kenyan market fail to carry out these searches within the market and also on the trademarks register. And sometimes it then emerges after the entire merger transaction has been carried out and completed and implemented that some pre-existing right that is conflicting with the acquiring entity's own branding emerges. And a problem then arises in that context, especially where you have an acquirer that's entering into a regulated space, for example, the financial sector, where the CBK is the regulator. We've seen instances where the CBK has required merging entities to get clearance for the new brand before the rebranding exercise begins. Now, where such a situation arises, an entire transaction could be brought to a halt and a rebranding exercise could be made impossible simply by the lack of conducting a full due diligence, not just on the target and its brands, but also on the acquiring entity's brands, in case those are the brands that are to be rolled over once the acquisition is completed. So the long and short of it is this: whenever a corporate rebranding exercise is being undertaken, the marketing teams should always speak to the legal team from the earliest possible stage. There should be free communication, there should be a continuous exchange of ideas and feedback on whether the new brand that's being adopted or the direction being taken by the business from a branding perspective is one that is sound and one that can be protected by law once it's been rolled out. So it's critical for organizations to take into consideration all these factors, some of which are set out in the law, while considering doing a corporate rebranding.